When the Constitution was written in 1787, some states were reluctant to sign it because it did not list or enumerate the basic fundamental rights and freedoms of the American people. They thought those rights needed to be spelled out, but others argued that listing only some rights would imply that any rights not listed belonged to the government and not to the people. James Madison, who's called the father of the Constitution, settled that issue by including the Ninth Amendment in the Bill of Rights. The Ninth Amendment states, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." In other words, the rights of the people are not limited to those spelled out in the Constitution. And because a right is not listed, enumerated, does not mean that the government can use its powers to prohibit the people from exercising that right. The 10th Amendment states, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people." The intention of the 10th Amendment was to ensure that the federal government would not dominate the states. It was intended to maintain a balance of power between the federal government and the state governments by limiting the federal governments to the powers enumerated in the Constitution. Among those powers are the power to declare war, to regulate commerce between the states, but not within a state, and with power to collect taxes. The system of government that divides power between a central government and individual state governments is called federalism. The first government created by the new nation was not based on federalism. It was a confederation. A confederation is a loose association of strong, independent states with a weak central government. Fearful of a strong, overpowering government like the British system they had fought against, the new nation created the Articles of Confederation. Almost from the outset, it was seen as ineffective. So at the Constitutional Convention of 1787, the nation's leaders created a different government, one based on federalism. Power was divided between the central government and the states. After the Civil War, in the period known as Reconstruction, the 13th, 14th, and 15th Amendments to the Constitution were passed by Congress and sent to the states for their approval. They are often referred to as the Reconstruction Amendments. The 13th Amendment abolished slavery and formally outlawed slavery in the United States. The 15th Amendment guaranteed all men the right to vote, regardless of race, color, or previous conditions of servitude. The 14th Amendment was aimed at protecting the rights of the freed slaves in the South, and it addresses numerous aspects of citizenship and a citizen's rights. The phrase in the 14th Amendment, "equal protection of the laws," is the most widely referenced phrase in legal actions and used in various landmark cases. Initially, the protections offered by the 14th Amendment were interpreted very narrowly by the Supreme Court. That was apparent in the slaughterhouse cases of 1873. This was the first judicial ruling on the 14th Amendment. The case began in 1869 when the state of Louisiana granted a monopoly to one company to slaughter animals around New Orleans. Independent butchers, represented by John A. Campbell, argued that the law violated the butchers' rights under the 14th Amendment because it deprived them of the privilege of operating a slaughterhouse and earning a living. Eventually, the case reached the Supreme Court. In a 5-4 decision written by Justice Miller, the Supreme Court ruled that the 14th Amendment did not apply because the Equal Protection Clause of the 14th Amendment applied only to the federal government and not state governments. In addition, the court said the independent butchers were not deprived of equal protection nor due process because they could still earn a living. At the end of the 19th century and throughout the 20th century, there were numerous landmark Supreme Court decisions that further defined equal protection of the law. Plessy v. Ferguson was heard in 1896. The case involved the strict segregation laws of the Jim Crow era in the South. In 1890, Louisiana passed a law that established racially segregated railroad cars, one car for whites, another car for blacks. Homer Plessy, who was biracial, was arrested for sitting in a car reserved for white people. He was tried and found guilty of violating the law. Plessy challenged the conviction. The law, establishing separate railroad cars, he said, violated the 14th Amendment. Eventually, his case reached the Supreme Court in the case Plessy v. Ferguson. The court ruled that the Louisiana law did not violate the 14th Amendment, which it said applied only to political issues and not social issues. And the court said, as long as there were railroad cars for both races, even if they were separate, the Equal Protection Clause of the 14th Amendment was met. And so, the policy of separate but equal was established. In 1942, the United States was at war with Nazi Germany and Japan. In February of 1942, President Franklin Roosevelt called for the exclusion and internment of all Japanese Americans from the West Coast by signing Executive Order 9066. Fred Korematsu, an American-born citizen of Japanese descent, refused to go to the government's internment camp. Korematsu was convicted for defying the government order. He appealed to the Supreme Court. In a 6-3 decision, the court sided with the government and ruled that the exclusion order was constitutional. Chief Justice Hugo Black and the court found that the need to protect against espionage outweighed individual rights. Another case of equal protection reached the Supreme Court in 1945, when the Shelley family purchased a house in St. Louis, Missouri. Unbeknownst to the family, there was a restrictive covenant placed on the property that placed racial restrictions on ownership. The court ruled the enforcement of a racially based restrictive covenant in a state court would violate the Equal Protection Clause of the 14th Amendment. In 1946, Irene Morgan boarded a bus traveling from Virginia to Maryland. She was ordered to sit in the back of the bus, as Virginia law required. Morgan argued that since it was an interstate bus, that the law didn't apply. She was arrested and fined. Thurgood Marshall and the NAACP argued that the Supreme Court decision in 1877 ruled that it was illegal for a state to forbid segregation. Then, likewise, it was illegal for a state to require it. The U.S. Supreme Court struck down a Virginia law requiring racial segregation on commercial interstate buses because it violated the Commerce Clause of the United States Constitution. Separate but equal, the mainstay of segregation in the South, applied not only to railroad cars but to all public facilities, including public schools. Then, in 1954, in the case Brown versus the Board of Education, the Supreme Court ruled that separate schools could never be equal. They were inherently unequal. In this landmark decision, the justices unanimously ruled that racial segregation in public schools violated the Equal Protection Clause of the 14th Amendment. While the ruling in Brown versus the Board of Education did not end segregation in the United States, it was a turning point in the rising civil rights movement. The 14th Amendment has been challenged in the area of sex discrimination, too. Ida Phillips claimed she was denied employment on account of sex. The company, Martin Marietta, had a policy of not accepting job applications from women with preschool-aged children. The Supreme Court decided that one hiring policy for women and another for men violated the law, particularly since both male and female applicants had preschool-aged children. Over the course of the 20th century, the 14th Amendment was interpreted more broadly. The Supreme Court came to recognize that most of the freedoms protected by the Bill of Rights extended to the states as well as the federal government. At the end of the Civil War, the United States entered a period of rebuilding, of reuniting the states that had seceded back into the nation. This period is known as Reconstruction. During Reconstruction, 3 amendments were added to the Constitution. The 13th Amendment, abolishing slavery, was ratified in 1865. But the South resisted the idea of establishing governments that recognized the citizenship and rights of former slaves. To counter this, Congress proposed the 14th Amendment. It went into effect in 1868. The 14th Amendment grants anyone born in the United States, including former slaves, full citizenship and, therefore, the rights of all Americans. Principal among those rights is equal protection of the laws. That means that all people within a state will be treated the same way. The 15th Amendment, which went into effect in 1870, gives the right to vote to all male citizens regardless of race, color, or previous condition of servitude. The Equal Protection Clause of the 14th Amendment was clearly intended to make the rights and privileges granted in the Bill of Rights binding on the states as well as the federal government. But for many years, the Supreme Court refused to recognize that intention. In 1896, in the case Plessy v. Ferguson, the court ruled that a Louisiana law establishing separate railroad cars based on race did not violate the Equal Protection Clause. The majority decision stated that the 14th Amendment was not intended to enforce social, as distinguished from political equality, or a commingling of the two races. And the court said, as long as there were railroad cars for both races, even if they were separate, the Equal Protection Clause was not violated. And so the policy of separate but equal, the mainstay of segregation, was established. Throughout the South, there were separate schools, separate water fountains, separate sections of movie theaters, separate everything. But notice, the ruling in Plessy said that the 14th Amendment guaranteed political equality, and the 15th Amendment granted black males the same voting privileges as white males. To get around that, and to deny voting rights to blacks, the Southern states passed restrictive laws requiring literacy tests for voters, poll taxes, and grandfather clauses, which denied the right to vote to anyone whose grandfather had not been eligible to vote. Those restrictions applied to both races, even though, of course, no black man's grandfather had been allowed to vote, and so the Equal Protection Clause of the 14th Amendment was not violated. But Jim Crow laws, as segregation laws were called, did not stop African Americans from fighting for the equality guaranteed them by the Constitution. The first major success came in 1954 with the landmark decision Brown versus the Board of Education of Topeka, Kansas. The decision declared segregated schools unconstitutional because they did not offer all school children equal protection of the law. Separate educational facilities, Chief Justice Earl Warren wrote, are inherently unequal. The court's decision ushered in the modern civil rights movement. 10 years later, Congress passed the Civil Rights Act of 1964. The law banned segregation in all public places, such as hotels, restrooms, and restaurants, and established the Equal Employment Opportunity Commission to prevent job discrimination. The following year, President Lyndon Johnson signed the Voting Rights Act, which prohibited literacy tests and other laws aimed at restricting African Americans from voting. The 14th Amendment's guarantee of equal protection has been used to ensure the rights of others who have faced discrimination. The Individuals with Disabilities Education Act was passed in 1975 to ensure that children with disabilities receive a public education equal to that of other children. In 1990, Congress passed the Americans with Disabilities Act, which guarantees people with disabilities reasonable accommodations in the workplace, public and commercial facilities, and public transportation. When the 14th and 15th Amendments were proposed, many women hoped that they would be granted the same rights given to men, especially the right to vote, but they had to wait another 50 years for that to happen. In 1920, the 19th Amendment giving women the right to vote went into effect. The Equal Pay Act of 1963, the Civil Rights Act of 1964, and the Equal Employment Opportunity Commission applied the Equal Protection Clause to women. The fight for equality and the protection guaranteed by the 14th Amendment is ongoing. Racial profiling, equal pay for women, and the rights of all Americans facing discrimination based on race, religion, ethnicity, or gender are issues that are still being addressed. A landmark case involving the Equal Protection Clause was decided by the Supreme Court in 2015. In Obergefell v. Hodges, the court affirmed the right of same-sex couples to marry. That right, Justice Anthony Kennedy said, is also derived from the 14th Amendment's guarantee of equal protection.